Hi, welcome to our webinar tonight on the probate process in California. We are going to be discussing three major topics tonight. We're going to talk first about what happens when you die without any estate planning whatsoever in the state of California. This is called intestate planning. And intestate planning is basically when you decide that you want the state of California to determine what's going to happen with your assets. The state of California says that if you die without a will and you have more than $150,000 worth of assets or any real property realistically, that the state must get involved in how to distribute your assets to your family, friends, etc. The way that they do this is through court proceedings, and there are fees associated with all of that. The fees in California generally start somewhere in the $400 to $500 range for your initial filing. And then after that initial filing, there are additional fees. There are assessor fees for any pieces of real property. There are also fees for There are fees for the probate examiner. There are fees if there are an accounting that's required, and there can be all sorts of other fees that can go along with that. There are also statutory fees in the state of California that are determined for people such as your executor. Some people also call it the administrator of your estate, and also for any attorneys that are involved in the probate of your estate. Now, these fees, the statutory fees, do apply whether or not you die intestate, with a will, or if you bring a trust to court. Now, bringing a trust to court, we will talk about later. Some people choose to do it, some people don't. But basically, with intestate, what happens is that the court, the state, decides what happens with your estate. And that happens anytime that you own more than $150,000 worth of assets in the state of California. What can happen with that is if you were married and, say that you wanted to leave everything to your children from a prior marriage, you and your spouse are both, well off from before getting married, and you've decided that she has children from her first marriage and you have children from your first marriage, and you two are just going to leave things to your children, not to one another, the state will come in and say, no, I'm so sorry, but that's not how we're going to do this. Your spouse is entitled to a portion of your estate. So those are the types of things that can happen when you die without a will. Dying without a will is not what most people do. There are some people who choose to do what's called a holographic will or a simple will. A holographic will is a fancy term for a will that I wrote up all by myself. And California does recognize those wills. So if you do choose to write your own will, you absolutely can. Just make sure that you write the entire thing in your own handwriting. Don't go and get a form from somewhere and just change a couple of things here and there and sign at the bottom. Make sure that you do write the entire thing by hand with all of it laid out how you want your assets split out. Now, a holographic will also go through the probate process. It will be taken to court, and it may or may not involve attorneys, and the statutory fees will apply, and all of the regular court fees will apply as well. So anytime that you're dealing with a will, or you're dealing with more than $150,000 worth of assets and no will, you will go to probate court. Something we should mention about probate court is that the average length of time for a probate in California these days is approximately 28 months. So you're talking about a little over 2 years, 2.5 years to finish a probate in the state of California. Some obviously go through a lot faster, others can take a lot longer. I've seen probates that have lasted up to 10 years. So those are some of the basics of what people consider with no will whatsoever, or what they might consider with a holographic will. So something else to consider is a will that is, prepared by an attorney, or that is prepared by somebody else, or those form wills that I discussed. Some people do choose to go and use that type of method for setting aside their assets. And that is certainly a way to determine who gets your things when you die. Unfortunately, there are some problems with just a straight will. So we mentioned the probate process and how long it can take and how expensive it can be. All of that will happen if you have a will. So if you have a will in the state of California and you have more than $150,000 worth of assets, sometimes even if you have less than $150,000 worth of assets, but you've left a will, then you can end up in probate in the state of California. When you go to probate for the state of California, you will be required to put an advertisement in the newspaper notifying all of your creditors that you've died and that a probate action has been opened. And I say you, but I mean your executor or your administrator. So they will make a notification to the local newspaper who will put it out there, and that starts a clock ticking for your creditors to come and to make a claim against your estate. That claim period is approximately 4 months. It can vary depending on when the publication is run, how long it's run for, whether or not it's all done properly the first time around, or if it needs to be republished. All of those things can affect your publication date and therefore affect your creditor's period of time for notifying the court that they have a claim against your estate. But generally 4 months for creditors to file claims against your estate, stating that they're entitled to some sort of reimbursement for a claim against your estate. So that is one thing to take note of when you do die with a will, is that you will absolutely have your creditors notified of the fact that you've passed, and they will know exactly where to come looking for anything that may be owed to them. You also will have all of your normal statutory fees through the court system. You will have your filing fees, you'll have your account fees, you'll have your probate examiner's fees, any assessment fees for your home or any other real property that you may own, as well as incidental fees that'll come up along the way. Additionally, you can have executor's fees or attorney's fees. Now, when I mention attorney's fees, I just want to make certain that everybody knows that if you have an attorney and I have an attorney, but we're both in the same probate case, both of our attorneys make the same statutory fees. It doesn't matter who gets what and whether or not I'm the administrator, or if my interpretation of the will is correct and yours is incorrect, everybody gets paid. So that is one of the considerations for hiring attorneys and having them participate in the probate experience, is that every attorney gets paid the statutory fees. The executor or administrator of the estate also gets paid their fees unless they choose to waive those, or unless the will specifically excludes them from being paid for their services. So when you file a petition to have the will probated, it'll go before the judge. That you will give notice to anyone who could potentially be a beneficiary of the decedent. That includes people that they may have intentionally disinherited. So they all get notice, and then they get the opportunity to come to court and to explain why they should or should not be appointed as the administrator of the estate. They also get to argue about whether or not the will should be admitted as is, and if the estate should be distributed the way that the decedent, the person who died, wanted their estate distributed. Once the administrator is appointed, the people still get to come and argue about whether or not things are being administrated properly. All of those hearings delay things. All of those arguments delay things. Anytime that you have a lot of people getting involved, it can cause a delay in terms of how long it takes to get assets distributed. This is part of the reason that the average probate in California takes over 2 years. There are sales of real property that have to happen. There are arguments about who is entitled to what, whether or not a decedent actually intended something, and all the rest. So those types of things do contribute to the long length of time in terms of how long it's going to take to get an estate probated in the state of California. The other thing to consider is that all of your information is made public when you have a probate in the state of California. As soon as the will is admitted to probate, it becomes a matter of public record, and anyone can go and take a look at your case file and see an entire copy of the will and what was intended to be distributed and to whom and in what amounts. So these are all things to consider. You need to consider privacy. You need to consider creditors. You need to consider who all you're giving things to and whether or not you want them to be included in the process of the court process to see who should be the administrator of your estate. You also need to consider the use of attorneys and all of the fees that will be paid to them. One thing that I should note about attorneys' fees and about executors' fees, if they do go through the probate process and through the probate courts, is that those statutory fees are based off of the gross value of your estate, not the net value. So if you have a house that is worth $500,000 in California, but you owe $450,000 on it, all of your fees are based off of the $500,000 amount, not the $50,000 worth of equity that you have in the property. This can oftentimes mean that people will end up getting nothing by the time that things have managed to go through the entire probate process, just because it can get eaten up in all of those fees and all of the things that the court takes, that the attorneys take, that the executor takes, the cost of publication, creditors who have now been notified that they can come after your estate for things. All of these things, they do eat into the potential distribution for your beneficiaries, the people that you really intended to have some benefit from your estate. So these are some of the considerations when you're talking about either intestate or passing your belongings through a will. There are certainly things that a will is important for. We do include what's called a pour-over will whenever we do a trust, and that is simply if you forgot to put something into your trust, you need to make sure that there's a will to say, hey, I forgot to put something in my trust. I intended for this to be distributed along with all the rest of my assets. Other things that you can put into a will are your intentions for burial arrangements, your intentions for guardianship of children, if any minor children are left behind. These are the types of things that would be included in a will, and so we do include those anytime that we do a will. But those types of instructional pieces do not necessarily have to be probated through the court system, and therefore can save time and money for anyone who does go ahead and prepare a trust. So I just want to take this last little bit to talk to you about a trust. Especially in the state of California, I believe that a trust is generally the best way for just about everybody to go. A trust is a private document that allows you to pass all of your financial considerations along to whomever you want without it ever going through the probate system. You do not have to file anything with the courts. Nobody ever knows what your trust said. Nobody ever knows what you owned other than, of course, your banks and the title companies and things of that nature. But you don't have to publish. You don't have to tell creditors that you've died and, to come looking for things from your estate. Now, I do want to make one quick note about creditors. Creditors are still entitled to come after the estate if they do become aware that somebody died. So with a trust, even though things do pass without having to go through the probate process, there is still there's a chance that a creditor may come looking. And at that point, if you've distributed to the beneficiaries based off of the trust, they may come after the beneficiaries directly. So sometimes what people do is they'll set aside a little bit of money into a trust that is just in case a creditor comes looking. Other times what people will do is they'll just notify all of the beneficiaries, hey, if a creditor comes looking, you may have to pay that creditor off. These are some of the ways that you can deal with that. Another thing that people do sometimes choose to do is that they will actually probate a trust to the same exact way that they would probate a will. So particularly if you believe that there are a significant number of creditors, or if you just want to be absolutely certain that once the creditor time period has elapsed, that 4 months, that nobody can come after you for a claim, then perhaps you do decide to probate a trust. But most people choose a trust because it's private. They don't want to go through the probate system. They want their assets to pass quickly and efficiently to the beneficiaries. So the way that a trust does that is you take all of your assets and you put them into a trust. Sounds very simple, and it realistically is. It is some documentation that you put together. We have a notary who comes in to make sure that you are who you are who you say you are, so that we can make sure that you're of sound mind and all the rest of that when you make these decisions. We take your assets and they no longer belong to you in the legal sense, but of course they're still yours. You can set yourself up as the trustee, or you can set someone else up as the trustee. So sometimes people will do this where, you know what, hey, my youngest daughter is really good with money and I want her to handle all of my finances and everything. So they'll set up the youngest daughter as the trustee, even though mom or dad is still alive. Sometimes mom and dad want to handle their own finances. They've always handled their own finances and they intend to continue handling their own finances. That's perfectly fine. You can have a trust and still be completely in control of all of your assets and all of your finances. What you are doing is creating a legal entity to take care of your assets so that they are protected from the probate process if that's what you choose to do. With a trust, things can pass seamlessly after your death. You can take titles and a copy of the trust, and you can have property transferred immediately. You can have bank accounts transferred immediately. All you have to show is a certificate, a death certificate, or an affidavit of death to the institutions that hold all of your trust documentation. Your trust documentation should name a successor trustee. The successor trustee would be someone who takes over after something happens to you, whether that be mental incapacitation, physical incapacitation, or death. Once that person takes over, they can act just as you would and distribute the assets according to your plan that you've already laid out. Now, a trust can also be useful because, as I mentioned, you might be physically or mentally incapacitated even though you're still physically here. A trust can account for that and can make certain that somebody can take over in case any of those things happen. The great thing about a trust is that should you regain capacity at some point, then the person who was your successor trustee can turn everything back over to you. And again, it's all seamless. There's no issue with any of this. The other thing is that with a trust, you can certainly lay out how much you want to pay an executor, but there are no statutory fees. So there's no fees to pay to the court. There's no fees that must be paid to an executor. There are no fees that must be paid to an attorney. Your executor or administrator of your trust, your successor trustee, can determine all of that. You can determine whether or not a successor trustee gets paid at all. If they do, how much and what would be a reasonable amount, in your opinion, for them to get paid. They also can negotiate directly with attorneys or other financial personnel that they may need to in order to administer your trust effectively. All of those things can be negotiated at a rate that is reasonable based off of the size of your assets and how much work is going to be involved. There are no statutory minimums. So that is a great advantage of a trust. As I mentioned, another advantage of the trust is that it's completely private. A private trust does not go through the probate process unless you choose to, which means that nobody knows who you left what to, how much you had, what you had stashed away where, and whether or not you left 10% to one child and 90% to another child. Nobody knows that except for the people who are actually involved in the administration of your trust. So it's a very private way of dealing with your assets. Another thing to consider with it is that there are no fees to the courts. So that $500 filing fee is not there. The probate administrator's fees are not there. There are no appraisal fees for any real property that you may own. None of that applies. Now, something that I didn't mention earlier, but I do want to go back to, is that I mentioned that there are appraisals on real property anytime that a will is probated or that you pass through the courts on an intestate basis. So with an appraisal of your property, what happens is the court is notified of what your property is worth. And then your administrator is expected to sell that property within 10% of that appraised value. I've seen this where we have had to have appraisals redone multiple times because we couldn't come near to the appraised value due to things such as foundation issues, liens against the property, etc. So in order to deal with that, we ended up spending thousands of dollars on appraisal fees and having it reappraised. Whereas with a trust, you don't have to deal with any of that. Your administrator or your successor trustee is simply given permission to sell your property or to transfer your property to whomever you've decided and to make the best decisions that they can regarding cost, price, etc. So that is a great advantage of having a trust over going through the probate process. Some people have talked to me about joint tenancy as an option for dealing with their real property. Now, joint tenancy is an option and some people do use it, but it is not an estate planning tool. What happens with joint tenancy is that when somebody dies and the property is passed from one person to another, there is what's called a step up in basis for the portion of the property that was transferred to the remaining spouse. That can be avoided in certain manners through proper trust administration. Since the property belongs to the trust and not to any individual person, even though one trustee or one beneficiary of the trust may have died, it doesn't change the basis for things like property taxes that you would when the title actually transfers after the death of a joint tenant. Now, you may say, oh, that's not a big deal. I just won't transfer the property when my husband dies and my children can deal with it when it's all said and done. The problem with that is that the state assessor will go back and will assess those taxes on the property to the date that the first joint tenant died. So you can now end up with a huge property tax lien that must be paid before you can deal with any sort of transfer of title or anything else. These are just some of the small problems that I've seen with title problems, joint tenancy, wills, etc. So just to review, and of course this is just the very basics on these 3 ways of dealing with your property, but you essentially have 3 choices in California. You can make no plan whatsoever and the state of California will decide for you what's going to happen with all of your property. That's called dying intestate. That requires that you go through the probate process and you will pay tens of thousands of dollars in fees to the court system for them to determine how your property will be distributed. You will have no say in it whatsoever, and neither realistically will your beneficiaries. Another way that you can deal with it is to have a will. There are several types of wills. One is called a holographic will. That's the one that you're going to write out completely by hand so that we know for sure that it's everything that you intended it to be. Another would be just your simple will that would be drafted by an attorney or that you might find in forms online. Now, a will get you where you want to go. It will get your things distributed how you intended them. Unfortunately, it still will go through the probate process and it will cost tens of thousands of dollars in fees. There are statutory fees for attorneys, for executors, and then of course there are all of your regular court fees. So that will happen if you leave nothing but a will behind and you have $150,000 worth of assets. Remember that with a will, it also becomes public record and you will have the publication for all of your creditors so that they will be notified about the fact that you have died and that there are assets available for them to come after. Also, lastly, remember that all of the fees, all of the statutory fees are based off of the gross value of your assets, not the net value. So that may mean that you're paying more in fees than you actually have in assets. The last way to deal with dying, let's just be real, that's what we're talking about here. The last way to deal with dying and with planning for your estate is to create a trust. A trust is a private document. Nobody ever sees it unless your administrator decides that it would be best for it to go through the probate process. You save tens of thousands of dollars in court fees, administrator fees, attorney's fees, and creditors coming looking for your assets. You also save tons of time because the assets can be transferred immediately without waiting the statutory 4-month period for creditors' claims and without having to go through the court process, which is currently running at about 2.5 years to get through a probate in the state of California. You save all of that. You have privacy, you save money, and you get to pass things along seamlessly. A trust also allows you to deal with periods of incapacitation in either your mental or physical state, and then you can regain control of your assets at a later date if you regain capacity. All of these things can be established through a trust, but they cannot be established through a will or through intestate succession planning. For these and many other reasons, we always encourage our clients to take a look at a trust and determine whether or not it's right for them. Generally, anyone who owns more than $150,000 worth of assets or owns any home whatsoever in the state of California ought to consider a trust. It is a small output in the beginning, but the savings on the back end and the amount of stress that you will save yourself and your family is immeasurable. A trust can also go along with a business succession plan and other planning for your business so that if your main source of income is as a family business owner or a small business owner, that can be planned for and your family can be taken care of long after anything might happen to you. So I will open the floor up now to questions. But I just want to also invite you at the end of this to go ahead and sign up for our introductory event. I will be running that with Heather Christensen. She is the CEO of CFO To Go, which is an online bookkeeping service, and she also goes into your business. We will be doing an introductory event in March on March 25th and 26th. And we will be discussing the life cycle of your business from start to finish, both legal and financial considerations for your business, particularly geared towards small businesses and family-owned businesses. As I mentioned, sometimes making your plan for the end of things is actually the beginning of things for the rest of your family.